Yes, Your Honor.
All right, Mr. Stafford, if you could announce your name, the name of the case, and the cause number.
Yes, Your Honor. Cause number DC 1907536, Kobe Equipment LLC and Slim RGB Finance LLC, and that's who I represent as plaintiffs.
Your Honor, Andy Kaplan, I represent Slim Texas Food Ventures LLC, defendant.
And Your Honor, there is another named defendant that is in bankruptcy currently, of which the proceeding has been stayed, and it's Zulkarnain Rajput, ZULQARNAIN RAJPUT.
Okay. You may proceed.
Yes, Your Honor. Thank you. I don't believe this will take too long, but on May 12th, there was a bench trial between the plaintiffs and defendant. And Your Honor, you have judgment creditor's motion to compel judgment debtor Slim Texas Food Venture LLC's responses to plaintiff's first set of post-judgment discovery request. I understand we have a record, so do I need to slow down in how I'm speaking, or is it just recorded?
No, Tony will tell you. She's not shy. She'll tell you if you're going too fast.
Okay. Yes, Your Honor. And so on the May 12th bench trial between the plaintiffs and defendant, Slim Texas Food Ventures, only the Slim Texas Food Venture LLC was tried. The Zulkarnain Rajput portion of the case was stayed. A verdict was rendered as to the one defendant. Judgment was entered on May 16th. Pursuant to Rule 192.3 and 621A of the Texas Rules of Civil Procedure, post-judgment discovery was propounded on May 26th as plaintiff's discovery to defendant / judgment debtor Slim Texas Food Ventures. And that included some interrogatories, production requests, and requests for admissions. We did receive responses June 29th, which were in the form of objections and responses. Upon review of those responses, Your Honor, there were absolutely no documents attached to those responses. There was no verification. There were no documents attached, which in the opinion of the plaintiff's judgment creditors is contrary to both Rule 196 and 621A. There was indication that such documents would be supplemented, which is in accordance with the duty of counsel and all parties to do so. But there was no date certain as to that. There was no verification as to the interrogatories under 197, and contrary to 197 and 621A, all objections are waived and proper responses need to be provided to those interrogatories. There were answers to the admissions under 198, but pursuant to 198 and 621A, any objections that could have been raised must be valid. The admissions are actually not designed for objections except as to privilege, and any objections are not to impair an answer, but are to be admitted or denied with respect to the portions that could be admitted or denied. And so on July 3rd, we actually sent a pretty formalized pre-motion to compel conference document, which addressed the specific numbers of the requests for the productions, the interrogatories, and the admission numbers, which were objectionable, requested that the objections be removed, indicated that the objections to the ROGs had been waived for lack of verification by the defendant or the defendant's authorized representative, and requested production of the proper documents, even those that had been said that they would be supplemented as to a date certain. I received no response to that pre-motion to compel conference from July 3rd, and filed my motion to compel, which is before this court today, on July 13th, which was last Monday. We did receive outreach from defendant's counsel yesterday evening about 6 o'clock, a little bit after 6 o'clock, indicating that he had been on vacation and that In addition, his office had been infected by the COVID pandemic, as have all offices, but that there had been a shutdown of sorts and that he wasn't sure whether he could produce the base labeled documents to me. I responded this morning and indicated, please supplement, please withdraw your objections, and please produce the documents. He did produce 196 base labels documents this morning, which are consisting mostly of bank statements. That does not entail the entirety of the request, Your Honor. There are other documents which were requested, including income and expense statements, tax returns, other things, which we have not received. And so I come before you because we haven't received the documents which we're entitled to post-judgment. We do know that there are the documents that do exist, and they were evidenced by the fact that documents were produced today. And we would ask the court to compel the production of the remaining documents in accordance with their discovery request. And we would request our fees for having to come before this court to file this motion to compel.
Response?
Yes, Your Honor. First of all, the vast majority of, we responded timely to the request. This is not even a final judgment as of yet, but there were two basic categories of documents that we said that we had. That was the bank statements, which we produced this morning. And again, as I mentioned, and I did state that to Mr. Stafford, my office was shut down as of July 3rd when he sent his pre-motion. My client sent them by mail. I was on vacation for the last 10 days before that. I came back to the office. I flew back into Houston yesterday, was up at the office yesterday, saw that the bank statements had been received, had somebody come up to my office this morning. Today's the first day my office has been open since our people were infected, and had him bait labeled and sent off to him in an effort to try to not come before this court and burden the court with something that we don't have an issue with. The tax documentation, I'm in the process of getting it. The tax preparer who's got the information was dealing with the July 15th deadline. I should have it this week. Those are the two major areas of documents that we said we'd produce, that have produced produced all the bank records. And I'm more than happy to produce the tax returns, as I said I would, and any backup data with the tax returns, which is what we said we had and we would produce. The objections, I have very few objections, Your Honor. I didn't object to very much here. With regard to the verification, by the way, Your Honor, because of the COVID, I didn't have a way to get over and get the verification done, but notwithstanding, I didn't really object to anything. There were two objections that I recall. One was Mr. Stafford sent a request for admission that said, admit that you had access to a bank. I don't really, to me, that was overbroad, vague, and ambiguous. Access to a bank is a poorly drafted, in my estimation, request that I didn't quite understand how to respond to. But if that was one. And the other objection that we had was he had a blanket request for production saying, produce all documents. This is in the interrogatories, produce all documents that that you are using in response to your interrogatories, which is kind of all over the board. So we really haven't objected. I'm not in any way, shape, or form trying to be obstructionist here. To the contrary, we've answered everything. I'm happy to get him those documents. There was really no reason for us to come before you on this. I could have clearly, I tried asking Mr. Stafford to be conciliatory. He insisted that I produce everything today and withdraw my objections today, or he was going to go forward. So here we are.
So what has not been produced at this point that you still need, Mr. Stafford? Mr. Stafford, you're muted.
Oh, I am, because I don't know what has not been produced, because I'm not the holder of the documents. I only know what I've requested. And I also know that, notwithstanding an explanation that a person was out of town or that they were on vacation, they could have simply said that they were on vacation, responded to the pre-conference attempt, responded in some way, not ignored an attempt not to come before this court. And my response to the defendant's overture at 6 o'clock last night, after not hearing anything for 2.5 weeks, was withdraw your objections, which are to request for production 48 and to request for admission 5, which we still assert are invalid. Supplement your answers, which you said you would, and produce all relevant documents. And so I can't say what hasn't been produced. I know certainly a business that's an ongoing or even a past concern has an income and an expense statement. The defense attorney has indicated that there are tax returns which haven't been produced, which are different than income and expense statements. And any specificity regarding additional bank accounts, we did receive 196 documents regarding Chase accounts today. There was a statement that there were 4 accounts available or used by the defendant. And so we don't know that we have all those documents. And so,
excuse me, Your Honor, just
Your Honor, I appreciate the question. It's just that I don't know what we haven't gotten yet. I know that we didn't get anything until today.
Your Honor, if I may respond, we were very clear in what we had and what we had to produce, and we were very clear what we didn't have. And what we had was bank statements, which we've produced today, a 2018 tax return, and any work papers related to that. Those are the things that we said that we had that we would produce. There's nothing else in there in those requests. We either said we don't have them, or there are some documents that were requested that are in the record already based upon affidavits put in the underlying agreements by and between these parties. So that's what we have. We've produced the bank statements. I need to get the tax returns and the work papers, and we will have produced everything that we said that we had in our responses.
And Your Honor, under number 7 of the ROGs, there's indication that there are 4 separate accounts at JP Morgan Chase. I certainly haven't received a representation or any supplementation to say that the 196 base level documents we received today addresses either the production regarding those 4 accounts or the nature of those 4 accounts. But to the extent that that representation wants to be made today on the record, that's fine. I guess if they're saying that's all there is as to these bank accounts.
Your Honor, to my understanding, the documents we provided were for all 4. All 4 accounts were under Chase. They were for the operating locations, which have now long since been shut down, and they've been produced.
Mr. Kaplan, let me ask you this. So clearly, there's still documents that you have not produced yet, correct?
The 2018 tax return and the work papers associated with that, which I told I try hopefully get that this week.
All right. And then you don't know of any other documents that are responsive that are in existence. Is that correct besides that?
Right. Based upon our responses, that's what we said we had that we would produce. All the other ones, there's a lot of nuns. We just don't have them. We don't have documents responsive to those other requests.
All right. I'm going to order those documents to be produced within the next 2 weeks. The objections that were filed are overruled, and you're to answer those also within the next 2 weeks. Anything else?
Nothing further from me, Your Honor.
Yes, Your Honor. Briefly, the specific objection to request for production number 48 and request for admission number 5, we would like those addressed with this court.
I've already overruled them. Mr. Stafford, I just overruled them.
Okay. And I just wanted to make sure it addressed those. And then we also had requested deposition dates, potential deposition dates for a designated representative of Slim Texas Food Ventures, LLC, and that was ignored. So part of the motion to compel was to get potential deposition dates for that representative.
What dates, Mr. Kaplan, is your client available?
I'll check with him, Your Honor. I assume we're doing this by Zoom, Mr. Stafford?
Yes.
Yes.
Okay, I will check, and I will have him dates before the 2 weeks is out as well. I'll try and have it before the end of this week.
You're to provide him, and just so this is included, Mr. Stafford, I hope you're writing all this down because I'll need an order on this. Mr. Kaplan, you're to provide him 3 dates for depositions by Wednesday, and the deposition dates need to be within the next 30 days.
Very well, Your Honor.
You need to give him 3 dates between now and the next 30 days, and you need to provide those by Wednesday.
We will do that, Your Honor.
Anything else, guys?
Nothing from me, Your Honor.
Nothing further, Your Honor. Thank you.
Thank you for your time, sir.
Thank you, guys. Mr. Stafford, if you could go ahead and email Rhonda and e-file a proposed order that governs everything, and try to get it to me by tomorrow if you can. Okay.
I will. I'll run it by opposing counsel first.
Thank you,
Perfect.
Judge.
Thank you, guys. You be safe out there.
Thank you. You too.
Thanks.